to see where the miscommunication was.
Because it shouldn't be that.
Because she doesn't believe it should be that expensive either.
Yeah, I
She said
just,
she'll call and then get back to me.
because we have other people that we've done this with before, and I never heard of the 70. Court calls the case, People versus Chloe Whitsett.
I'm Kia Hickman, standing in for the attorney of record, Caitlin Crapo, PA 6783.
All right. Okay, and what are we doing today?
So I spoke with Caitlin and she emailed me the compliance for the bond. So she said that we would be going over
Pardon?
the compliance for the bond, the non-compliance.
Are you here on this one?
Nope, I'm not.
Okay. The compliance for the bond.
Yeah, and then she said to set a new date. I'm just standing in for Caitlin. So
No, I hear you, but I'm just trying to figure out, so I can set a new date. I guess I'm trying to figure out the first thing that you said to me about compliance with the bond.
yeah, she brought up to myself and Ms. Chloe that she was emailed a report from bond compliance for pretrial release.
But the progress report?
Yes.
Oh, okay, all right. And I guess, hey, let's deal with that then. Do you have a medical marijuana card?
Yes, sir.
Let's see. Has provided a copy of medical marijuana card, issue date of the 20. All right, so let me ask you this, ma'am. They got you to test it on site in Detroit, right?
I wasn't able to.
Because you couldn't afford to do it.
Yes, sir.
Okay.
They wanted $70 and I didn't have it.
No, I got you. Is that the only place there that because our tests are what? Well,
yes.
She currently lives in
the Detroit area. And so they had her go to onsite, but the test is 70. So she was having issues with transportation. So, but at that, she could Uber
here.
take the darn test and get back for what they're trying to charge her. Right? It's crazy. All right, let me.
I mean, I'm not sure if you want me to.
Well, it has to be an approved site.
Right.
That's the problem, but they can't take folks and have us charge 12 and say, okay, you want to test and then charge 70. I mean,
We agree.
and she goes there and then she can't do it. And it looks like she's in violation, but it really is just, she didn't have the $70. It's one thing trying to scrape up 12 if you ain't got it, but trying to scrape up 70. We're gonna try to sort that for you, see if we can find you a place, okay? Ms. Whitsett.
Yes, sir.
Ms. Whitsett, how you doing?
Again, I'm here.
Okay, but no, hold on. Because you remember the first time we met. You remember that day.
It's famous.
It is?
Yes, sir. I remember.
Because you were having a day.
My life.
And then you wanted to spread it to everybody. And everybody didn't want to have all that.
And I apologize, Your Honor. I truly do.
The good thing is I could tell that you were having you were just having a bad time and just needed to do whatever. Okay. And that's probably the only reason you didn't go back there. I could tell if you calm down, got stuff situated, you'd be okay.
Well, I thank you, Your Honor, for having such excellent discretion with people because I needed your help.
Yeah, and I remember when I tried to say something to you, and she was by the door. She turned around, just not by the door there, by the gateway to the well. And you just turned around and just snapped at me. I'm like, okay.
Oh, my medicine.
What did you say?
I don't think I was on my medicine either. But I do apologize.
I could tell something was wrong. Then you came back the next time. You were a little better. You weren't quite like you are today. But I said, she's working at it.
Yeah. Ms. Wild is going to contact on-site to verify information regarding that.
Very well.
Regarding the price of the testing in Detroit, to see where the miscommunication was.
Because it shouldn't be that.
Because she doesn't believe it should be that expensive either.
Yeah, I
She said
just,
she'll call them and get back to me.
because we have other people that we've done this with before, and I never heard of the 70. So what kind of tests were they trying to give you? I mean, that's the other thing.
Well, they said all panels. So I don't know what that means.
That's everything.
Right. But I guess, and then it was in Troy. Yes, it was out, not that far from where I'm at, because I'm like closer to 8 Mile, but it was out in
Oh,
Troy.
okay.
And there was quite a bit of,
Where was it?
I have to look at the address. I have to look at my
Okay, let's do this then. How much time out how much the adjournment, how far out?
Let me know that she's available in July. So
She's married.
I have her schedule.
All
Every
right.
court is like, I'll let her know. But every district court is different. So I don't want to say a date and, it's not proper, but
Every district court is different.
they are.
I know, they really are. But we're the only ones that do it right.
Okay. So she told me July. I'm thinking July 11th. It's clear for her.
Yeah, okay, it is.
Yeah.
That's what I'll do then. That's a Thursday, so. So I'll adjourn your probable cause conference to July 11th, 2024. I set it at 9, but she'll get a time block for the block assignment.
Okay.
Okay. And then what did she want her to do? She's gonna call and verify and get back to us now, or
Yeah.
does she want her to?
I did come here this week because I just had to drop yesterday, the day before yesterday. So I was able to get here this week and drop.
Gotcha.
So
Okay.
next week, I don't know what, I guess depending on what day.
Right.
I can share whatever information Wild shares with me with council.
All right.
Every day.
So here's what we'll do. I'll just, at this point, I'll just continue your bond. I'm not gonna, I got why that happened. We're gonna get information from community corrections. She's gonna double check into the price and everything like that. And rather than have you guys wait, unless you want to wait, we will then email what we get to council.
Okay.
So that way you know, and then they'll communicate it.
Perfect.
That'll work.
Yes, sir.
All right. Fantastic.
All right.
Thank you so much, Your Honor.
Bond continue.
Thank you.
Mr. Westside, you made my day. I know, shocking. You wouldn't have thought that 3 or 4 times ago, but you made my day because you came in here finally and you're smiling. And
Well,
that makes me happy to see, because that means
I'm glad I-
through whatever you were going through, you're enjoying life a little bit more. And that's what it's all about. All right,
Thank
you take care.
You too, sir. Have a good one.
Nice meeting you, Judge.
Yes. Court calls the case, People versus Dolores Strickland.
Good afternoon, Your Honor. Rachel, Assistant Prosecuting Attorney. and Mr. People.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Strickland. Ms. Strickland, will you please state your name for the record?
Dolores Strickland.
Your Honor, we are here today for a bond violation hearing that was set, as well as a probable cause conference. I think the reason that was initially set is we didn't have an opportunity to review those calls with our client. At this time, Ms. Strickland does wish to admit to the violation of contacting the complaining witness in this case. And then we would ask that the matters be set for preliminary examination.
Your Honor, for the record, I did have some communication with Ms. Apple via email. I didn't make an official offer, but suggested that it's something we could negotiating. What I would not have included in that offer would be any reduction of the child abuse third degree. I also would have wanted restitution on all counts, even any counts we would dismiss as part of that plea agreement. The purpose of which was, it is very important to us in making offers, especially things like this, that don't go through having to testify. But again, that was not an official offer. My understanding is that Strickland does want all matters set for exam, so we'll see it accordingly.
All right. People have I'm presuming that you have all the discovery.
Yes, to our knowledge, yes, we have all the discovery.
You will be ready on the 25th?
With that, could set out an additional week, I'd appreciate it.
Any objection from the defense?
Do you want it on the 25th? Are you okay waiting a week?
I mean, the ultimate issue is that they get started on the 25th and then get an adjournment and probably go out further.
Your Honor, Ms. Strickland indicates she'd asked that it be set for the 25th. These cases have been pending some time. She's been in custody for quite some time, so we would ask that they set at the earliest date available to the court.
Thank you.
Okay, well, here's what I'm gonna do then, you know. June 25th, 2024, 9 a.m. That's in person. I'm gonna put it before Judge Washington, and here's the reason that I'm doing it. If people don't have all of their witnesses, particularly on some of these cases, you could certainly start the exam with Judge Washington on the 25th. Judge Washington, who would then have to take it, is up that following week on the 2nd. So certainly, and I'm not promising anything for her, but at least it gives you some leeway to get you to your week without having to do it the other way.
Your Honor, I think I'm and I'm not completely confident, but I believe Mr. Strickland may be in custody on at least another matter.
You are?
I don't- It's just those three files
Just the three
that
cases.
are up, to my knowledge. I didn't go looking though, so,
Yeah, that's it, Your Honor. That's-
Okay,
okay.
all right. Well, we'll set it for the 25th before Judge Washington.
Thank you.
Thank you. Does the recall the case, people versus Jadon Marita.
Mr. Sinatra, Senior Assistant.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Edward Martell, P 85051, on behalf of Jaden Merida, who joins us at the podium. Mr. Merida, please state your full name for the record.
Jaden Meredith.
Judge, if I may.
Go ahead.
Judge, first and foremost, let me apologize to this honorable court, certainly for my tardiness and or absence earlier. I was caught into a Third Circuit capital case, and so certainly my humblest apologies. As it relates to this particular case, Judge, we're respectfully demanding an in-person examination on both matters. I would humbly ask for separate dates as they're not related, and I would humbly ask for after July 1st, as me and myself and Mr. Nasser have an upcoming federal matter in Bay City.
Are people going to have any issue with July dates?
Your Honor, I have not had any conversation with counsel, but if that's what he wants, and that's fine with me. We will always have somebody available for a preliminary examination. July dates will accommodate that.
Is all discovery complete, counsel?
It is, Judge.
In case 24 FB 21208, preliminary examination in person. Are these related? Why would you need separate dates?
Judge, they're absolutely unrelated. One is allegation of
So you
within
don't
the
need
jail.
separate dates.
Judge, I will leave it to this fine court's discretion. If Your Honor wants to do it on the same day, that's fine.
Preliminary examination will be set for July 2nd, 2024, 9 a.m. before Judge Perry, both cases. Found
Thank you,
continued.
Judge. Always a pleasure. Thank you again.
Thank you. Calls the case, People versus Douglas Wren. Your name, sir?
Douglas Allen Wren.
Thank you.
Your Honor, we're just going to ask we need to see some video. If we could have a 30-day adjournment.
30 days to watch a video? Seriously?
I don't want to jam up Mr. Ganatra because I realize he is the
You will
foundation.
never be able to jam.
He's
up
the
Mr. Ganatra,
foundation.
So I don't even know what you're thinking.
He's the foundation of the prosecutor's office. He needs to be, be treasured and honored, and I don't want to jam him up. I want to give him enough opportunity to get the video.
You would not be able to even
Sounds like
do
my
that.
mom.
I know.
And I love that. That's really stupid.
Thank you. I hope that'll go into the
I feel-
applications as
Boy,
well.
oh boy, I feel all warm and fuzzy. All right. So you need 30 days.
Yes, please. And part of it, Your Honor, he's doing terrific in transitional housing. This is the best that he's ever done. And we would like to give him an opportunity to keep it going. And Mr. Ganatra has been kind enough to work with us and see if we can keep what has been the best recovery he's had in many years, going on track.
Sounds good. It's good to hear, Mr. Redray.
Yes, sir.
Probable cause conference in this case, July 18th, 2024, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
I gave an extra week because I don't want to jam Mr. Ganatra up through.
I will have to think up some new compliments for Mr. Ganatra during the extra week.
All right.
Thank you, Your Honor.
Thank you. Calls the case, People versus Michael Viger.
Good afternoon, Your Honor. Mike Hamlin, Assistant Prosecuting Attorney for the people, sending in the president. Thank you.
And good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Michael Vijay.
Oh,
Standing to my right. That's okay. Judge. I
Is that
screw
how
up all
it's
the time, Your
pronounced?
Honor, so. What's that?
How's your name pronounced?
Vijay.
Okay, that won't
It's
happen.
like French, Judge.
No, I really.
Okay.
Seriously.
That's how I remembered it, Your Honor. I wasn't accusatory.
Judge, in case you.
Judge, I just reminded myself how I remember it. Sorry.
All right.
I apologize.
Okay, all right. Okay, what are we
You
doing?
gotta remember, I'm standing in front of a celebrity by the TV. Your Honor.
No.
You knew that was coming, didn't you? Come on.
Okay,
Your Honor, regarding the case.
yes.
Sorry. Judge.
We have a forensic interview scheduled on June 17th for the victim in the case. I would like to have this ECC after that takes place. We are very hopeful that the victim will be brought for the interview. This is the second time. The first time the paternal grandmother was supposed to bring him. She did not. Now he is with his mother, so again, we're hopeful that will happen. If we could get in, I believe, defense and I are stipulating to an adjournment, because I think that's.
Okay.
A day past the 17th, that would be appreciated.
We're not objecting, Your Honor. Obviously, we'll let the people kept their case run its course, Judge, and we have already waived the days before today.
So, right, you'll have the interview and then at some point, you're gonna have to kind of analyze it and try to figure out what the heck's going on. So, you want the 27th or the 11th?
I would be okay with the 27th or the 11th, Your Honor, is whatever council's preference.
The 27th is fine, Judge. We actually compared calendars, so that's fine. Oh, sorry, Judge, can we have the 11th? My client. Oh, 27th is fine, Judge. Sorry.
Will that work? Sure.
Okay.
June 27th, 2024, 9 a.m. or as your invite indicates, bond will continue.
Thank you very much.
Thank you, sir. Court calls case of the People versus, is it LV Jackson?
Andrew Childers appearing on behalf of the people, Your Honor.
It is.
And may it please this honorable court. And may it please this honorable court, good afternoon. Byron Pitts, ready on behalf of Mr. LV Jackson, who appears by Zoom and consents to having this hearing by Zoom.
Mr. Jackson, can you turn on your camera and state your name for the record, please, sir? Counsel, your client is not connected to audio. We've sent a message to him, but I don't, well, and he just, no, he's still here. Oh, there he is.
There we go. Perfect. At work.
Mr. Jackson, can you hear me, sir? I see him. Pardon? He hasn't connected to audio, but let's see. I don't know what we're gonna do. Mr. Jackson, if you can hear me, wave your hand in the air. Yeah, I don't. He's not even hearing me. Oh, he's trying to, I think, read. He's trying to read my staff's messages to connect to audio. I don't know what he's saying. I think he was swearing at the machine. Oh no. Counsel, he just dropped, I'm sure. Okay, I'll pass it. Let's see if he signs back in. I bet you he's gonna just start over. Let's hope. Okay.
Judge, let me step away. Let me try to call him and tell him.
Okay, all right. That'd be good.
Maybe I can facilitate straighten this out.
Okay, not a problem.
Okay.
All right,
Okay.
thank you. I'll pass it. Court calls case People versus Christian Philippe.
Andrew Childers appearing on behalf of the people.
All right, where is he? Is he coming in?
In about 1 minute,
I ain't got a minute, man.
55 minutes. Mr. Phillips, sit here and state your name through the judge. Christian Philippe.
Thank you. All right, what are we doing?
Your Honor, we are requesting a 2-week adjournment. A possible or make up our minds going forward with the prelim exam. I've been in discussion with the Prosecutor's Office regarding this.
2 weeks you want?
Billy?
Good afternoon, Your Honor. June 25th for his calendar.
All right. Probable cause conference, June 27th, 2024, 9 a.m. as your invite indicates. Bond will continue. Thank you. Court does call the case, People versus Joseph Lozier.
Your Honor, Michael Vincent, on behalf of Joseph Lazier, who is in my waiting room. He is en route to this location. He's got troubles walking, a little bit older. I should be here within a minute and a half.
Two should race. No. What?
We'll get Mr. Burkett. Andrew Childers appearing.
Yeah. What? I can say that to Vincent. He gets it. Everybody thought I was being cruel. Mike knows it. He gets it.
I put my money on Mike.
Oh, definitely. It's a horse race. I'm betting on Mike. I don't even need to see the other horse.
State your name for the judge. Good afternoon, Your Honor.
Good afternoon, sir.
Yes,
What are we doing?
Your Honor, there's been a plea offer. I wish the prosecutor would put the plea on the record so the client could hear from the prosecutors.
Your Honor, I spoke with Mr. Vincent on the phone yesterday and we discussed a plea to an added count of a reckless discharge in return for a dismissal of counts 1 and 2. It's my understanding, I think, that Mr. Vincent wants some time to speak with his client about that. I have no objection to offer open.
All right.
Just for clarification's sake, that is a misdemeanor, correct?
That is correct. It's a 90 or 93-day misdemeanor, something like that.
I believe my client wishes to accept that plea and interview right now. I've discussed it with him prior to coming in.
I don't have the form written out.
I'll need to prepare that form, Mr. Vincent, unfortunately, but we could come back on the 27th and I can have it all squared away on that date.
That's fine.
All right.
Sorry about that.
June 27th, 2024, 9 a.m. or as your invite indicates, bond will continue. All right. Thank you, folks. Mr. Ganacha, please.
Good morning, Your Honor. Mr. Knapp, Senior Assistant Prosecuting Attorney on behalf of the people. Your Honor, at this time, the people move to create a conflict between this honorable court, the Office of the Public Defender. The Prosecutor's Office does not believe a conflict exists, but if there's one present, we waive all the cases today between my office and the Public Defender's Office before this honorable court. Thank you.
Thank you, sir. Mr. Brown.
Good morning, Your Honor. Good morning. Royal Brown, Deputy Chief Public Defender appearing. Your Honor, we likewise do not believe that any conflicts exist in this honorable court hearing these matters. If a conflict were to arise, we waive that conflict so that this honorable court could hear these matters.
Thank you, Mr. Brown. Court, for its part, also does not believe there's a conflict either in the court rules or the cases dissent thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case, People of the State of Michigan versus Maurice Anthony.
Mr. Ganacha, on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Davi Liba on behalf of Mr. Anthony. Mr. Anthony, could you state your name, sir?
Maurice Anthony.
Thank you, sir. What are we doing?
Your Honor, today we'll be requesting an adjournment in order to review discovery with Mr. Anthony.
Where are you located? You're in Livingston. Yes. Preliminary exam. How long do you, Mr. Anthony, how long are you going to be in there? Do you know?
Just to tomorrow.
Just till tomorrow? Okay. Then what I'll do is I'll set it out to the 2nd.
PCC, Your Honor.
Yes, for PCC. I'm sorry, not a preliminary examination. Probable cause, July 2nd, 2024, 9 a.m. or as your invite indicates, bond continues.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case, People versus Mark Austin.
Mr. Ganacha for the people.
3 cases.
The Public Defender Hannah Apple appearing on behalf of Mr. Austin.
Mr. Austin, can you state your name, please?
Mark Austin.
Thank you.
Your Honor, my understanding is that he still remains incompetent. We did not receive a report regarding an update, so we would ask for an adjournment.
I do have a copy of the report. Does the court have a copy in its file?
The June 10th report?
The report is dated June 10th, sir.
Yes, sir.
Okay. I can hand a copy to Ms. Apple.
Thank you.
I'll actually give it to her because I have an electronic copy. But the people don't have any objections to the adjournment request, but we also agree with the findings of the report. They believe that I'm just giving the thumbnail for Ms. Apple's benefit.
All right, but you're not looking to have that happen today.
Correct.
All right. One other issue, and I'm not sure what we do with this because he's incompetent at this point, or at least been determined to be that. He also has an arraignment on a knee charge.
Okay.
That's also assault on a prison employee.
Yes.
Your Honor, I have no objection to adjourning that if that's what counsel wants.
All right. So the competency hearing, I'll adjourn. How long did you want?
Your Honor, 90 days. That's too long.
What are you trying to accomplish within the 90 days, I guess? Are you?
I haven't had a
do an
chance to
IME?
review the report, but if,
Are you looking to make an assessment on an IME?
oh, understand. Your Honor, just 2 weeks so that we can review that.
Oh,
Thank you. Sorry, I was misunderstood. Thank you.
why don't we just do July 2nd, 2024, 9 a.m. On that, I'll also adjourn. I'll adjourn both cases and the arraignment to that date.
Understood.
All right. Okay. Thank you.
Thank you.
Thank you, Mr. Austin. Court calls the case People versus Michael Fritz.
Andrew Childress appearing on behalf of the people, Your Honor.
Good morning, Your Honor. Leslie Knapp appearing on behalf of the defendant, Michael Fritz. And to my left, state name.
Michael Fritz. He's waiving preliminary examination.
We are, Your Honor. I have explained to Mr. Fritz his absolute right to a preliminary exam, and at this time he wishes to waive it.
All right, Mr. Fritz, you understand that would be a hearing where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 and 3 following. So as to the arraignment on the information, you waive formal reading.
We will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute to all 3 counts, court will enter a not guilty plea. Pretrial will be set for
July 24th at 1:30 before Judge Conlon.
July 24th, 2024. At 1:30. That's before Judge Conlon.
Yes.
Before Judge Conlon.
Thank you, Your Honor.
Thank you.
May I address one issue? Mr. Fritz lives in Plymouth. He has,
Apparently that's yes. Go ahead.
we're just asking that the random drug screens be transferred to Jams in Westland. He's having a problem getting out here for them. His only transportation.
Well, the way that would work is you can contact the prosecutor's office. You
Okay,
can do that by stipulation if they would so agree. An order would need to go over to community corrections. Your client would have to sign a release with JAM so that the result will be reported to community correction so they could be forwarded to the court and the people as well as defense counsel.
I'll take care of it. Thank you, Your Honor. Great day.
You do the same. Court does call the case People versus Peter Heenan.
Assistant Prosecuting Attorney Morgan Baroque on behalf of the people.
Good morning, Your Honor. Christopher Whitman, P75395, on behalf of Mr. Heenan, who is walking up with me to the podium, will be standing to my right momentarily.
Your name, sir?
Peter Heenan.
All right, what are we doing?
Thank you, Your Honor. We just substituted in yesterday. We did receive police reports from the prosecutor's office. Appreciate that. We believe that there might be video of the interviews with the complainant in this matter. We would ask for a brief 2-week adjournment to get those videos and to reset this for PCC at this time.
Any objection from the people?
So, Your Honor, I do just want to note that at this point, all of the discovery that we have has been turned over to defense. I will make an additional request to make sure that they have, that there is no additional videos from Ann Arbor that we are not in possession of, but at this time they have everything.
Probable cause conference, July 2nd, 2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. I do want to briefly address one bond condition. This is an aggravated stalking case. It's alleged my client made contact with his recent ex-wife twice through our family wizard with some unkind words, and then having some items delivered to the home. There was no allegations of any kind of direct threat nor any in-person contact, things like that. He was in jail for 6 days. There was no contact attempted there. He's been out for 8 days. There's no attempted contact there as well. We would ask this court to step down from a home confinement to a GPS with exclusion zones, radius around.
You have to file that as a written motion. I'm not going to hear that at this point in time.
Okay, Your Honor.
I want all the facts before I make a decision on that. Bond continued. Thank you.
Do you want me to set that for a July 2nd date or is further date, Your Honor?
If you get the motion in, give adequate time for the people to respond. We'll reset your probable cause conference likely to the 3 o'clock block here, your PCC and your motion all at the same time.
Thank you, Your Honor.
For that efficient.
Thank
Thank you. Court does call the case of the people versus Keandre Allen.
Morning, Your Honor. Jake Hill on behalf of Mr. Allen, approaching the podium. Judge, on this matter, can we set both matters for an exam?
All discovery is complete. And would the people have their witnesses available on the 25th? Preliminary examination in these matters will be set for June 25th, 2024, 9 a.m. That is before Judge Barr.
There is one additional matter.
Of course there is. Go ahead.
I notified Mr. Kilwell last night via email that there were 2 calls that the defendant made to the victim after his arraignment. I requested that those phone calls be released to Mr. Kilwell last night. If he has not already received them, he should be receiving them shortly, but as a result, I will be asking for his phone privileges to be revoked today.
Judge, I have not received them yet. I haven't been to my office this morning, but that being said, Your Honor, I would just ask that I've instructed Mr. Allen not to make any phone calls to the parties involved.
When did these alleged phone calls take place?
The 9th, Your Honor, both on the 9th.
What calls case people versus Darian Crystal?
David I. Goldstein appearing on behalf of the defendant.
And pull your pants up. Next time wear a belt. You're in court. Understood?
Yes, sir.
State your name.
Darren Crystal.
All right. What are we doing on this?
Your Honor, I was just retained in this matter earlier this week. I do have some discovery, but I cannot say that I have the complete discovery. So I'm asking for a 1-week adjournment.
I give you 2.
That'd be fine, Your Honor.
At this point, Mr. Goldstein, I believe, should have everything that we have. However, I did make a supplemental request to the sheriff's department earlier this week because I do think that there was an additional audio recording and supplemental report from the defendant's arrest, which was listed under a different incident number. So we do not have that in our possession. I also want to make Mr. Goldstein as well as the court aware that there is a warrant that has not yet been reviewed that was submitted for Mr. Crystal for a controlled substance related offense. A charging decision has not yet been made on it. It was submitted to our office on April 24th. I just pulled it from the queue this morning and we'll be reviewing it today to make a charging decision. I will let Mr. Goldstein know what that charging decision is. At this time, I have not even read the report yet, but there is potentially an additional case coming for Mr. Crystal.
Your Honor, I was aware of the potential of that charge. That's something that happened long ago. So it's not something that happened since he was charged in this matter.
Okay.
That is correct. It was submitted to our office prior to this case. The offense date on this case that is in front of us today is June 5th. So it does predate that.
Got it. June 27th, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Brian Pinneran.
Can am I heard, Your Honor?
Yes, sir. Go ahead.
This is James McWhale, Special Assistant Attorney General on behalf of the people.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Finnerman, who I believe was supposed to be here via Zoom today.
I don't have him. He's not signed in. Uh-oh.
Your Honor, I'd asked, I spoke to him Tuesday evening, we submitted the Zoom request. My office contacted him. He said he had the Zoom permission. I don't know if there's some mix-up. I'd ask the court for a potential, perhaps a show cause or to pass this matter to see if I can reach him on the phone.
No, he was supposed to be here. We've had a failure to appear before also in this case, and he's now not here again. How much child support is owing?
This matter, Your Honor, a little over $8,500.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $8,500 cash. That warrant will issue immediately.
Thank you, Your Honor.
Thank you.
Your Honor, does the court prepare its own bench warrants or do you want us to do it?
We take care of that.
All right, thank you.
Calls the case, People versus Israel Crane.
We're ready in this matter. Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Israel Crane. Mr. Crane, state your name for the record.
Israel Crane.
Thank you. Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
Discovery is all complete.
To the best of our knowledge.
People would have their witnesses available the 25th. Preliminary examination in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
I do just have one thing I would like to address with the court.
Yes.
So Mr. Crane was in Michigan because he requested to be supervised while being out for his conviction for armed robbery and FA out of Virginia. Agent Bennett, who I believe is supervising his release here in Michigan, notified our office this morning that he believes that the defendant is having contact with the victim through his mother. I do want to note that I don't see I was not able to find any jail calls to the victim directly from Mr. Crane, but I am concerned based off of the need that Agent Bennett felt the need to notify us of this. I have not had an opportunity to have a discussion with Agent Bennett with regard to this allegation or what the basis for it is, but I am concerned. I have not had an agent feel the need to contact our office to notify me of indirect contact on.
Okay, but are there then phone calls that would even remotely substantiate that, like phone calls to his mother?
Yeah.
But the content of those particular phone calls, we don't know.
I have not.
Mr. Brown, I'm not sure what
I think they're asking for his phone privileges to be revoked, but
they haven't said that he's had any contact. They haven't shown that he's directed anyone to do anything. We don't even know the extent of his mother's relationship with the complaining witness in this case. Without those facts, they're not asking for anything. They're just putting that out.
Here's what I'll do. Is somebody going to be able to listen to those calls to indicate? I mean, it's one thing if he's contacting his mother and his mother is then reaching out in some way, whatever, as opposed to him attempting to try to send messages through his mother. There's going to be a difference. So I'm reluctant to do anything until such time as there's some indication that that's what's happening in terms of a third party contact. So maybe if you get a statement from the officers to how they know that, and what information has come to them, get that to Mr. Brown and to the court. I may change that decision so that you're aware, Mr. Brown, where if I look at it and it appears to me that that's the case, then I may revoke his privileges, and you can certainly have a hearing before Judge Washington or this court regarding that. Okay. So I think that's probably the best way at this juncture to handle it.
Thank you.
Okay, thank you.